Hi, everyone. My name is Dupsy Olutufeshe, and I'll be moderating the webinar today. I want to say a massive welcome to everybody. Just a little introduction about myself. I am a domestic abuse officer with Look Ahead, with 8 years working experience with women and children fleeing domestic abuse. Currently working in Look Ahead's Women's Refuge, I do advise, I support, and I advocate for women and children from diverse backgrounds. I also cover the community one-stop shop in Sevenoaks and Tonbridge for local people to receive advice in domestic abuse-related issues and signposting to appropriate agencies. So I want to say a massive welcome to everybody. Unfortunately, I can't tell you to say welcome to the next person beside you because we are all doing it virtually, the new way of working, isn't it? Okay, so this event, challenging police decisions to get the best outcome for victims, is part of 16 days of action to end gender-based violence. Kent Integrated Domestic Abuse Service have 16 events running between now and 10th of December to inform, educate, and inspire action so that we can make domestic abuse everybody's business. Because domestic abuse is everybody's business and everyone can make a difference, which is just what you're doing by attending today. So thank you very much. During the event, you are able to use the Q&A text box on your screen to ask questions for Nogah. As your moderator today, I will publish this and ask them at the end of the session. Nogah will be speaking for approximately 30 minutes and will then have 30 minutes for the questions. I just want you to know that your email confirmations show the webinar as slightly longer, so we don't get cut off on the system. You can use the thumbs up just underneath a question to upvote if that's something you would like to ask. If you would like to follow up on a question, please preface the question with the words follow up. Just for you to know, if the talk today affects you in any way and you would like to speak with someone, there is a pop-up number for help. Please call 0808 1689 111, or you can visit the website. So that just leaves me with the wonderful job of introducing Nogah Ofer. Let me say a few words about Nogah. Nogah Ofer is a solicitor with 18 years experience at a number of human rights legal firms, where she specialized in challenging state bodies, particularly in the criminal justice system and immigration detention. Nogah has acted in numerous cases involving failures in policing of violence against women, including inadequate investigation of rape and trafficking, domestic homicide, and sexual exploitation by police officers. Since 2016, Nogah has carried out policy work in the voluntary sector on a range of civil liberty issues and supervised a university law clinic. Nogah also has 2 years experience of supporting survivors as a volunteer on the National Domestic Violence Helpline. So help me welcome Nogah as your wonderful presenter today. And don't forget to put your question there, upvote any question you see you want us to talk about today or to answer for you, and I will be publishing it. So make sure you click the cross on your screen just to take off the pop-up on it. And then I will be going away for a while and I'll be back in 30 minutes. See you very shortly. Welcome, Nogah.
Thank you very much, Dupsy, for that introduction. And that was indeed my professional background. Just to mention that at the moment, I now work for Centre for Women's Justice. And I just want to say a little bit about what we do, just to give some context before I talk about the topic today, which is challenging police decisions to get best outcome for victims. So in terms of my legal background, I specialise in criminal justice system issues, but in civil law. So it's using the civil law where there have been failings. And Centre for Women's Justice, CWJ, we're quite a new charity. We were set up in 2016. And as you can see, hopefully on the slide, our mission is to hold the state to account on policing of violence against women and girls. And that photo is Harriet Wistridge, who's our director. So how do we try to hold the state to account? We do that in two different ways. One is strategic litigation, and the other is supporting the women's sector to use legal tools and to use the law. And that really is my part of the work. And what I'm going to be talking about today is really part and parcel of that side of our work. But before I get stuck into that, just to say a few words about strategic litigation, because that is a part of the bigger picture of using the law. So strategic litigation is where you bring cases that don't just implement the law that we've got, but that try to change the law for the future, for other people who will come along after your, particular case or client. And I think maybe many of you will recognize this particular ugly mug here. Normally when I do this training face to face, I kind of ask people to shout out names, and I can't do that. But you may recognize that as John Warboys, who is the black cab rapist. By the time he was finally prosecuted, the police accepted that there were 101 women who had been raped by him over about 6 years, during which time he hadn't been caught by the police. And Harriet Wistridge, our director, acted for 2 women who were raped by John Warboys in 2 pieces of strategic litigation. So I just thought I'd mention those quickly just to give examples of how you can use the law strategically. So the first one was a case which you may remember was in the news quite a bit in 2018, which is when the parole board decided that they were going to release John Warboys because he no longer posed a risk to women and to the public. The 2 survivors, the 2 women who Harriet acts for, wanted to challenge that. But before that time, the only people that had ever challenged a parole board decision were either the prisoner himself or the Secretary of State. But Harriet decided, well, let's have a go. Let's see what happens. So they did bring a judicial review, and I'll talk about what those are a bit later. It was an application in the High Court. And in fact, it did work. The High Court agreed that in this case, John Warboys had effectively pulled the wool over the parole board's eyes, and they were told to look at the case again. And indeed, they decided to keep him in prison, not to release him at that time. And in fact, he's still inside now. The other case that involves John Warboys was a case that took many, many years to reach the Supreme Court. It reached the Supreme Court again 2018, and it's now the leading test case on what the law is on the duty to carry out an adequate investigation, which I'll talk about a bit later. And so both of those cases have changed things for the future. In terms of the parole board, it led to changes in the parole system and more opportunities for victims to input and be involved in the parole process. And in terms of the case against the Metropolitan Police in the Supreme Court, it set out the legal test in the UK for the first time in terms of the duties under the Human Rights Act. So those are just some examples, but those are sort of big high profile cases, but you can use the law in lots and lots of routine cases to try to get better outcomes for victims and survivors. So what we do around legal inquiries, which are not strategic cases, but the more routine cases, is we have a resource hub on our website, which Frontline Women's Services can get the password to and can use those resources. We also give second-tier advice to workers at Frontline Women's Services to assist in cases involving their clients. And we have a legal reference panel of about 180 lawyers who give some pro bono advice if there are cases that we think need more detailed help or might go a bit further than the more limited advice that we can give. So that's what we do. And what I wanted to do today in this webinar is to make it quite practical around the rules and guidelines and sort of legal avenues and tools that you can use if you are working with women, survivors who are not happy with what's happening in the criminal justice system and want to try to challenge those things. I was told it's a level 3, so I've sort of prepared this, assuming that it's really for professionals who already work, in domestic abuse, whether it's in, women's services or elsewhere. But obviously everybody, I'm aware there's lots of other people on this webinar. There may be survivors, and I hope this will be useful for everybody, and very, very happy to answer any questions anybody might want to ask. Don't worry about anything being a stupid question. I hope it'll be accessible to everyone. So what I'm going to do is look at the different legal remedies that exist in sort of civil law that people can use to challenge police decisions, or sometimes CPS, prosecution decisions. And just to give examples of the kinds of things, the kinds of inquiries and cases that we tend to look at, that we get quite a lot of. There can be decisions to take no further action. So, if the police say to a survivor, there's insufficient evidence, we're not going to prosecute. And I know that the most recent, it's not very recent now, but the most recent figures from HMIC, the Police Inspectorate, is that about 24% of domestic abuse cases are closed where the victim, the survivor, does want to support a prosecution, but they've been told that there's insufficient evidence. So it's that group of cases. Another example would be, for example, in harassment and stalking cases. We often get cases where survivors approach the police wanting some help, and then instead of policing action being taken, they're told to go and get civil remedies, to go and get a non-molestation order or other civil injunction. And then sometimes even when they get a non-molestation order and that is breached, there isn't policing action to arrest the perpetrator for breaching those orders. So that's an example of the kinds of issues that we will often deal with. Another is failings around investigations. So for example, we see cases which are dealt with as common assaults when actually they could be dealt with as ABH. So an example of that would be strangulation cases, where CPS guidance does say that they can be considered as ABH, but many of those cases are dealt with as common assault, and where there was a 6-month deadline, often those cases are closed, either because the deadline's already gone by the time the woman has reported, or where the investigation has dragged on and the deadline's been missed. So those would be an example of women not being able to get the justice that they are seeking and that they deserve through the criminal justice system. So those are just a quick sort of few examples, so you've got a rough idea of what I'm talking about. So we've got 4 remedies here that I'm going to talk about. The first 2, victims' right to review and formal police complaints. There's nothing to stop you from just sort of requesting those and letting the police get on with it. But I think what I'd like to talk about is how to sort of get more out of the system so that the victim, the survivor, sort of maximizes their prospect of getting a good outcome, and not just being a passive recipient of the process, but being more actively involved and being able to input into the process and putting forward points and issues and information that they have to make it better, a better outcome. So I'm going to talk first of all about victims' right to review. So this is the only way that you can challenge a decision to take no further action, which is a decision not to charge an accused person, a perpetrator, which we call NFA decisions, as I'm sure most of you know. So for a decision to come under the victims' right to review scheme, a qualifying decision, it can include any NFA decision, but not a decision where you're challenging which offence is being charged or which perpetrator is being charged. It's only where the survivor is basically being left empty-handed because there's not going to be any prosecution at all. Also doesn't apply where the perpetrator can't be identified or hasn't been interviewed. So there is a time limit of 3 months, and that's 3 months from when the the victim was told that there's going to be an NFA decision, but there is a discretion to extend that time if there's good reason. So, for example, if the victim has been struggling with mental health problems, maybe other crises going on in her life, she's had to go to a refuge, deal with finding new schools for children, any kind of reasons why she's not been able to engage in time, then it's always worth asking and seeing whether there can be an extension of time. I mean, that tends to apply where it's more like days or weeks rather than years late, but it very much depends on the particular case. And there are two, to make a victim's right to review request, you can do it very easily by going to the Force website. So I know that Kent Police, if you Google Kent Police Victims' Right to Review, it takes you to a page where you can click on an email address, and that will be the address that you can submit a VRR. The same applies to the Crown Prosecution Service. Again, they've got a VRR scheme on their website. So there are two different schemes. One is the police VRR and one is the Crown Prosecution Service VRR. So you really need to know in your particular case who made the decision to take no further action. Is it a decision that was made by the police and the case was never referred formally to the CPS, or is it a case that was referred to CPS and CPS decided not to prosecute? And sometimes it might be the police who tell you the decision, but it was actually CPS decision. So it's quite important to ask that and to know that so you know which scheme you're going down. So the police VRR scheme has got a one-stage process. So the case will go to a reviewing officer. They will look at the whole case again. So the reviewing officer will be somebody who was not involved at all in the original investigation. It depends on local force policy, but in most forces, it'll be somebody who's more senior than the original officer who made the decision. And it needs to be somebody with kind of specialist knowledge of the case, of that area of cases. So if it's like, sexual offences or something like that, somebody with specialist knowledge. The CPS scheme is a two-stage scheme. So first of all, it'll be looked at locally in the same CPS office by another prosecutor. If that doesn't change anything, then there's an appeal to the National Appeals and Review Unit when the whole case will be looked at again from scratch. So just to say very quickly, when the police decide or the CPS decide not to charge, they apply what's called the full code test. That's got an evidential test and a public interest test. And in vast majority of the cases that you will be involved with, it'll be the evidential test. Is there a realistic prospect of conviction? It generally will be in the public interest to charge in a domestic abuse case. But when the police decide whether to send the case to CPS, they also apply that same test. So is it, the full code test is the same one. So just looking really quickly, I don't know if you can read that tiny writing. I hope you can. Very, very quickly, just to see where victims' right to review fits in to that bigger picture in the criminal justice system. So you've got the offences reported. So the victim sort of comes in top left and she's trying to get down to have her trial, bottom right. She gives her statement or video interview. There may be some input from CPS as early investigative advice, but basically the police apply the full code test. If they think it's not passed, then the police will give an NFA decision, and then there's a police VRR. If that succeeds, then that will go back and be looked at again. If they think the test is passed, then they refer it to CPS, and then the CPS apply the full code test. Again, if they think it's not passed, you'll get a CPS NFA decision and a CPS VRR. If the CPS think that the test is passed, they will charge. But before you get to a trial, there are two things that can sometimes happen. One is if the case is discontinued. If that happens, then again, the victim has got a VRR. And if that is successful, then they can have another bite of the cherry and the case can be looked at again and the perpetrator could be recharged, or the accused could be recharged. However, if it goes a bit further, usually very close to trial, if the CPS decide to offer no evidence, again, there is a victim's right to review. But if that's successful, unfortunately, it's not possible to have a trial because the accused has been formally acquitted. So all that would happen there is a decision that it was the wrong, wrong decision. If the victim's right to review is unsuccessful, which is very, very common, the only way to challenge that is by judicial review. In these kinds of cases, that is very hard because you can't do a judicial review just on the basis of how the evidence has been treated, because judges have said that they won't get involved with that. It's not like an appeal where you can ask a court to look at all the evidence and give their opinion. It has to be that there's been an error of law or a breach of policy or something like that. But certainly you can discuss that with a lawyer and see whether there might be a judicial review there, and we can easily advise on that as well. So the main thing with a victim's right to review, in order to do it well, you need to know, and the victim needs to know, what the reasons are for the NFA, because otherwise you're just shooting in the dark. There's no point in just repeating what happened during the offence, because the police and the CPS already know that. So to do a victim's right to review and to be able to kind of give the victim a voice to input into the process, you need to know, why has this case been NFA'd? And sometimes the police will say insufficient evidence, but that doesn't really tell you very much. What you need to know is, why is the evidence considered insufficient in this particular case? What is it about the evidence? Is it the victim's credibility? Is it something else? Is it what you need to prove the offence? Is it some other evidence? So the victim does have an entitlement to know the reasons, and the best thing to hang it on is those legal entitlements. So the victim's code says that the complainant should have the reasons explained, and those are the provisions there. Also says that sufficient information should be given to help the victim decide whether or not to pursue a victim's right to review. And then there are also kind of like wider principles of fairness in law. So that applies to any decision by a public body. If it's going to affect your life, then you should be given enough information so that you can input something that is meaningful into the process. So it doesn't mean they have to tell you absolutely all the details, but enough information to be able to have some kind of meaningful input. So it's really important to get the reasons first and discuss them with your client if you're supporting a victim or survivor, and only then ask for the VRR once you understand what the reasons are and you're ready to put in any kind of points that she wants to make in support of the VRR. Because if you request the VRR right at the beginning before you've got the reasons, then in many cases they'll just go off and do it without giving you time to put in any legal submissions, or not any kind of submissions. You don't need to have a lawyer. You can do this without a lawyer. So when you're putting in the VRR application, the test that has to be met is, why is the decision wrong? It's basically as simple as that. And anything that you might want to say about why you think, why the victim thinks the decision was wrong. So examples of that can be aspects that weren't known about, for example, to the police or CPS before. And what you may find in many cases is that the reasons that are given for the NFA include things that the victim has never actually been asked about, and she's never had the chance to give her explanation for those things. Because usually when she's given her original statement or video interview, she's been asked to say, what happened and describe the offence. But when you get the NFA, you may say things like, after you reported this abuse, you then went back to the abuser, or, something like that. And she's, when you said this to the doctor, you said something different, or this or that was recorded. And she's never actually had the chance to give an explanation for those things. So the VRR is really her opportunity to put forward explanations, further points. Sometimes you just can sort of show the decision makers things in a new light if you kind of put the wider context. To give that example, victims often do go back to abusers, and that doesn't mean the abuse didn't happen for all sorts of reasons. They may be, suffered coercive control. They may be under pressure from family, financial pressures, all sorts of reasons. And now's her chance. And then they can always reopen the case and take a supplementary statement. Or, for example, there may be offences that weren't considered before. Maybe it was considered as common assault, whereas actually ABH doesn't have a time limit. If the time limit is gone, the 6 months, maybe coercive controlling behaviour hasn't been considered. And then there may be evidence that's been ignored before, or maybe further evidence that she now realizes hasn't been obtained. Maybe they haven't contacted witnesses, or they haven't obtained her GP records, or she now can think of other evidence that would support the case. So this is her chance really to put forward those things. Or there might be errors of law in the decision making. I mean, the classic one that we've done a lot of work around in rape cases is where the police have said, well, it's your word against his, therefore, we can't prosecute because there's no corroboration. Now, if there's nothing particularly to undermine her credibility, then that isn't a correct application of the law, because you don't need corroboration. So things like that, again, it's better to have a bit of legal input. You can contact us, for example, for some discussions around what the law might be. But all of these things can be put forward to strengthen that victim's right to review and ensure that all the points that she might want to make are considered when the review is done. So I'm going to move on now to my second, and I won't say as much about the other remedies because I know I'm running a bit short of time. The second system I want to talk about is police complaint system. So essentially that is a misconduct or disciplinary system within the police. So it's an internal process, but there's a new, I've got a picture of AC12 there, but there's a new complaint system since February 2020. And it also looks at not just misconduct, but also whether there was an adequate service given, whether there's lessons to be learned, and other types of outcomes as well as misconduct outcomes. You can make a complaint in lots of ways. You can go onto your force website. You can go onto the IOPC website. That's the Independent Office of Police Conduct. You can walk into a police station and do it that way. Lots of different ways. Now, there used to be a 12-month time limit for police complaints until under the old system. Under the new system from February 2020, it says that there's no time limit, but the IOPC website does say that if you make a complaint after 12 months, it might not be investigated. So it's best to make all complaints within 12 months, wherever possible. And then in terms of who does what, the IOPC, even if you send your complaint to them, they will not investigate it unless it's one of a very, very small number that they do investigate, which are the most serious cases like deaths in custody, domestic homicides, corruption, that sort of thing. So the vast majority of police complaints are investigated by the same force that is complained about. And then the PCC, that's the Police and Crime Commissioner. Under the new system, a PCC can choose whether they want to be involved in the police complaint process with their local force. So you'd have to find out what your local PCC has decided to do. But some PCCs can be involved in taking original complaints, in communicating with complainants, in doing reviews, but others won't. But the actual investigation will still be done by the police force. And just a very quick overview of how the new police complaint system works. There's a more detailed guidance on our website if anybody wants to have a look. So I won't go into it in too much detail, but there are 4 steps here that I've set out. The first one is it under Schedule 3? So Schedule 3 is the formal process. And I would generally advise, unless the survivor wants to have something very, very quick and informal, generally speaking, I would advise everyone to say, yes, they do want to go under Schedule 3, because otherwise there's danger of sort of being fobbed off by something that's very informal. And then under Schedule 3, it can be done either with an investigation or without an investigation. So again, I would advise people to request an investigation. Now, you won't always get that. And the way that you can get an investigation is if you can show that the allegations that have been made, if they're found to be true, would amount to misconduct or breach of human rights, that's Article 2 or 3, then the complainant is entitled to an investigation. And misconduct can include lack of diligence, which is how the police officer or officers have done their job, whether they've done their job properly in terms of their duties and responsibilities. So that is the best way to try to get a full investigation. If it's done without an investigation, even if not everything is investigated, they can still investigate some aspects. So they can still interview some officers. They can still look at, for example, some documents, like officers' notebooks, custody records, and things like that, to look at outcomes. And then I have to say, I've so far only started to see the first ones coming through the system. I've seen one that was done without an investigation, and it was done extremely poorly, actually. So, I really hope that this new system is not going to reduce the standard of police complaints, and that we do get full investigations in most cases. Step 3 will be the outcome. So you could have a disciplinary system, you could have a disciplinary outcome, you could have unsatisfactory performance, unacceptable service, officers told to reflect on their practice, or you could have a complaint not being upheld. And then if the complainant is not happy with that, they've got a right to request a review within 28 days. That will either be done by the IOPC or by the PCC, depending on which type of complaint it is. Right, I'm going to just speed up a bit because I know I'm running out of time, so apologies for that. I'm going to say a few words about the Human Rights Act, because traditionally it's not been possible in English law to sue the police for failures in how they investigate crime, and that goes back to the 1980s and a case involving the Yorkshire Ripper, called Hill and West Yorkshire Police, where the mother of the last victim of the Yorkshire Ripper sued West Yorkshire Police for their failings in catching the Yorkshire Ripper, and that went all the way to the House of Lords, and they said no, it's not possible on public policy grounds to sue the police. Along came the Human Rights Act in 2000, which introduced the European Convention on Human Rights. Only about 10 years later, lawyers started using that to bring cases involving, gives a sort of legal basis to sue the police or challenge the police in terms of human rights duties. I've set out there probably the most useful cases. 2 of them are in the UK courts and 2 of them are European court cases. I'm sure these slides can be, made available if people want to look at those. So DSD is the case that I mentioned before. That's the John Warboys case, and that sets out the duties under Article 3 of the European Convention on Human Rights, which is inhuman or degrading treatment, and that is the duty to investigate rape. And there are 2 types of duties, I should say, under the Human Rights Act. There's a duty to protect, and that's to protect a known person at risk, so a named person who might be at risk of further abuse. And the other duty is the duty to investigate, where somebody has reported a serious crime of abuse. So this doesn't apply to like a burglary or something like that. It only applies to abuse and serious types of offences that involve human rights. Then we've got a case of Opers and Turkey, which is a domestic abuse case where there was a right to life issue because the mother of the victim of domestic abuse was also abused and eventually shot and killed by the perpetrator. And then a recent case, Volodina, which has extended the law in terms of domestic abuse to say that domestic abuse is inhuman and degrading treatment, even if you don't have physical violence, very much brings it in line with kind of coercive controlling behaviour and that sort of thing. And then we've got the case of Waxman, which is a case that was brought by Claire Waxman, who's now the Victims Commissioner for London. I don't have time to go into the details of that case, which is a really interesting case, but it's the one case in the UK where the courts have relied on Article 8 of the European Convention, which is the right to private and family life. That was a stalking harassment case. It was actually from before the stalking offences came in, so it was harassment then, but the behaviour would be stalking now. And the judge said that there is a duty on the state to protect victims from stalking and harassment. So that's also a useful case. And so finally, how would we as lawyers use these cases in kind of a real life situation? So first of all, a victim's right to review or a police complaint, those are mostly done without a lawyer. You don't need a lawyer to do that. I mean, we're very happy to give some legal advice around those. Some of the lawyers on our panel will assist with victim's right to reviews particularly. But if you want to kind of go to court, then the final 2 remedies on my list of 4 remedies would be where you would need a lawyer. So the final 2 remedies then are judicial review and civil claims. And just to explain the difference between them, so judicial review is where you go to court and you're asking the police to do something. And you're saying to a judge, please, can you quash a decision by the police, or any public body. So you basically have to ask the police to do whatever it is that you want them to do. And if they refuse to do that, then you go to court. You have to do it as quickly as possible. Although the deadline is 3 months maximum, you have to show the court you've acted really fast. So it's best to get urgent advice from a lawyer. The other type of court case is a civil claim, and that is not for when you're trying to get something to happen in the future. It's where there's been failings in the past. And it's really where the victim's trying to get some accountability, some recognition that there was an injustice done, that they didn't have their rights to the criminal justice system let them down and didn't give them what they're entitled to in terms of protection or investigation. So it's a civil claim for compensation. You need to show serious failings. Not every failing is going to amount to a human rights breach. It needs to be really quite a fundamental failing or a lot of failings in one case. There's a deadline of 12 months for that, which is really, really important to think about and be aware of. So get legal advice urgently if you think you've got one of those sorts of cases, though that can be extended if there's a good reason again. And just finally to say, there is legal aid available for those cases if the person qualifies financially. And so really that's it. Those are the legal avenues that are out there. I'm not saying that any of these things are easy. They are not a magic wand. They can take a long time to pursue. There may not be a positive outcome at the end. So I don't want to give any victims false hopes. But I think the important thing is that these avenues, these legal tools do exist. They are out there. If you are working with victims who want to pursue, feel they've been let down and want to try to challenge that or do something about it, or if you yourself a survivor and want to do something about it, these are the ways that you can try to raise your case and try to sort of resolve those things. They can take a long time, but they are there. And if you do want any additional help from us, please do feel free to contact us. You can go to our website and go to the Contact Us page and send a message through. So I'm sorry I've gone a little bit over my time. My apologies, Dupsy. Happy to hear any questions.
There's so much question coming up for you, Nogah, and I will go straight to it. The first question, by the way, thank you so much for this presentation. That's very, very wonderful and very highly informative. The first question is from Donna. Does the victim's right to review have to be made by victim themselves, or can the advocate, IDVA, apply on their behalf?
So yes, I mean, in many, many cases that we work with, support workers will submit the victim's right to review on behalf of their client, but obviously it needs to be where their client is asking for a VRR. So they'll need to, just to sign a consent to say that the IDVA is representing them and is submitting it on their behalf. But yes, that happens all the time. Yeah.
Thank you so much. The next question is from Caroline. Is there guidance available on how CPS reach a charging decision for stalking? What evidence or information are they expecting police to provide, and in what format? So many cases are reviews charge. I would like to ensure, what am I assisting my client with police reporting? And police have all relevant information before they pass on to the CPS.
Yes, so that's a good question. Thank you. The CPS website is incredibly useful, and it's got information on every aspect of violence against women and girls that you can think of. And there is, if you Google CPS harassment and stalking, there's very detailed legal guidance on there on the law around harassment and stalking. And all their legal guidance is written for their own prosecutors, but it's really useful for the police, for advocates. We use it all the time, for survivors, for anybody. So do have a look at that, and you might find that the particular point that you would help in your case. But one thing that you might want to look at, and again, this is available online, is in stalking cases, there is a checklist, and it's a checklist that the police have to complete whenever they refer a file to the CPS. There's a checklist specifically for domestic abuse cases, and there's also a separate checklist for stalking and harassment cases, and it's kind of 2 or 3 pages, and it's got a list of different types of evidence, and the police have to tick, whether they've considered or whether they've got that evidence, have they got an account for witnesses, have they got photographs, they've got medical records, and so on. So it's quite a useful checklist just to see, to trigger any ideas about what evidence there may be out there. And the checklist also asks the officer at the very top to say, have you considered why this case is not stalking? Because what we found in a lot of cases is that police treat cases as harassment when actually they are stalking. And there is a protocol that was drawn up between the police and the CPS in 2018 following a joint inspection report on harassment and stalking. So the joint inspection was the joint inspection between the police inspectorate and the CPS inspectorate in 2017. It's quite a damning report, actually. When you read it, it's quite shocking because although they start off saying they're sort of mixed findings, they're actually saying that both police and prosecutors really are not understanding stalking in many, many cases and are not dealing with them properly. And following that, the protocol was introduced. So again, you could Google that, or it's also available through us. And the protocol was introduced to try to kind of have a more robust approach to the policing and prosecution of stalking. So that might be worth looking at to see if there's something in there that would help your client.
Oh, thank you so much, Nogah. The next question is from Laura. Laura is asking, in a case where the CPS made a decision not to charge, do the victim get direct confirmation of the decision from the CPS that explains why and how they have arrived in that decision?
So it depends on the type of offence. So in all rape cases, the CPS have to provide a letter to explain to the victim that there's been an NFA and explain the reasons. But that doesn't apply to domestic abuse cases if there isn't a rape. It does cover a few other offences, I think racially aggravated offences and a few others. So in a rape case, there will be a letter from CPS, but in other cases, often the information will be communicated by the police, not by the CPS. And so that can be in all sorts of ways. It can be a phone call from the police. It can be an email, a letter, depends partly on the force because different forces have different policies and so on. Yeah. So if it comes via the police, it's really important to ask the officer, was this a CPS decision or was it a police decision, so that you know which VRR route you can go down. But also if it is a CPS decision, you can say to the police, my client is entitled to have an explanation of the reason. So could you please ask the CPS to give the reasons? And they could either send it direct to you if you're like an IDVA, or they might send it via the police. But it should be the body that made the decision should be the one that gives the reasons.
Okay. Thank you so much. Right. The next question is from Laura. In a case where the CPS made this, I think that's been answered by you.
The last one, yeah.
Good. Right. The next question is from Michael. What will happen when the UK exit Europe in terms of the ECHR? Is there any other method of appeal?
So basically, it's quite confusing, but there are 2 different systems in Europe, and the European Court of Human Rights is actually completely separate from the European Union and the European Court of Justice, which is part of the European Union. So actually, Brexit is not going to have any impact at all on our membership of the European Court of Human Rights. That is a separate issue. I mean, before the referendum, the Brexit referendum, there was some talk then about the Human Rights Act possibly being repealed by the government, but that was when David Cameron was in, but that's kind of been sort of put to one side now. So Brexit won't actually have any impact on our use of the European Convention on Human Rights or the Human Rights Act. In fact, it was European law that brought in the victim's right to review, but now the VRR is part of our law, I very much doubt that is going to change. So I don't think it will have any immediate effect unless there's some further political changes, one day in the future.
Yeah, that's good to know. I think many of clients would like to have more answers on that, and we'll try and keep an eye on that. Thank you. The next question is from Tina. Can cases discontinued at court be challenged?
So generally speaking, when a case is discontinued at court, it's usually because the CPS offer no evidence. And that means that I mean, this is all very technical, but technically it's not a discontinuance, it's offering no evidence. And so they're basically saying to the court, you know, we're not going to put any evidence before against this defendant, and the court has officially then found them not guilty. And that is where, in law, it's kind of the same as if it went to the jury and the jury found them not guilty. So although you can, although the victim does have a victim's right to review in that situation, if that VRR is successful, the only thing that will happen is that the CPS would say, oh, sorry, we made the wrong decision. But it's not going to be possible to get the offender, the accused, back before a court. The only exception to that, because that's the rule of double jeopardy, which is you can't prosecute the same person twice for the same offence. The only exception to that is very, very, very rarely you may get a case where this exception was brought in, which was brought in after the Stephen Lawrence case, and it's where you have compelling new evidence. So it would need to be something so new, completely blows the original case out of the water. You know, to give an example, let's say you had a rape case where the accused was saying, oh, you know, I wasn't there, it's a mistaken identity. And maybe a few years later down the line, there was found DNA evidence was found, for example, and that completely changes the game. In a case like that, maybe you could try and get a case reopened. But generally speaking, no, sadly, once you're at court, it's generally the CPS offer no evidence. It's really tough because when we've seen cases, you know, like particularly like rape cases, that can take like 2, 3, 4 years to get to trial, and the survivor finally gets to court, and then the wool is pulled out from under, the rug's pulled out from under their feet, and the whole thing collapses, and it's really, really distressing.
Yeah. Thank you so much, Nogah. The next question is from Donna. Is there a definition of victim that is used for the right to take formal challenge against the police decision?
I'm not quite sure what you mean in terms of if it's like terminology. I mean, there's lots of different phrases used, like victim, complainant, survivor. You know, women's sector tend to use the word survivor. You know, within the criminal justice system, sometimes it's the word victim, sometimes it's complainant, but it's the person who has reported an offence against them. I know in cases of fatalities, that will include the family of the deceased. I think the Victims Code has got a definition of victim, so you might want to look at that, because I know, for example, there's been issues around whether a person who is born as a result of a rape is a victim or not, and I know there's an issue about whether they should be included as a victim under the Victims Code. So I think have a look at the definition there, but it's generally the person who has reported the offence against them, so not a witness. For example, you know, somebody who's witnessed an offence, or who knows somebody who, you know, is supporting somebody like a family member, they can't. They're not a victim. It has to be the actual person who suffered the offence. Yeah.
All right. Thank you for that answer. Right. The next question is from Emma. If a restraining order is coming to an end and the victim feels still in danger, and the police have said that there is no danger, what can be done?
Well, I mean, I think probably she would need to be looking at applying for a civil order. It would so much depend on the facts of the case, because if the police believe that there is no ongoing danger, I mean, one option, you know, normally when a restraining order comes to it, you know, one option would be to try you know, you could in theory bring a judicial review and say that the police have got it wrong in how they assess the danger. But if it's a long time after the end of the case, the restraining order has been in place for some time, if something new has happened, then that should be enough to show that there is a continuing danger. But if nothing has happened for a long period of time, then it may be difficult to show that there is still a danger. So, I mean, it really depends on the situation. In theory, if there is a danger, she could try to challenge that by a judicial review and use Article 8, which is the duty to protect, which I mentioned before, which is the Waxman case. Or she could try to apply for a non-molestation order in the civil court. That would be the other option. Yeah, it depends on the facts of the case, I think.
Okay. All right. Thank you, Nora. The next question is from Tina again. Tina is asking, we are told that when perpetrators voluntarily attend the police station to be questioned, they cannot then be given police bail conditions. Can we challenge this?
So this is a really big problem, that I know, and we've been, I don't know if people are aware, but Centre for Women's Justice put in what's called a police super complaint to HMIC, which covers different protective remedies. And this is one of the things that we raise in the super complaint, which has been going on. They've been investigating it for 18 months now, and it's going to be finished quite soon, they've told us. But yes, the problem is that if somebody attends on as a voluntary attendance, there's no power to use bail conditions, because you can only use bail when you release someone from detention, and that person's never been detained if they came along on a voluntary basis. And that's why we have said that it's really important that in domestic abuse cases, the accused, the perpetrator, is arrested and interviewed under arrest and not invited for a voluntary interview, so that you can get bail conditions. I mean, one thing that you could try in that situation is, if the interview's been done already, you could say to the police, although you've already interviewed him, you do have the power to still go back and arrest him, purely for the purpose of having bail conditions. And there are a couple of cases, again, they're mentioned in one of those, mentioned in our super complaint, and you can contact us and we can give you details of those cases where the court has said that one of the grounds for why an arrest is necessary is in order to have bail conditions. So in order to arrest, it needs to be necessary under PACE, under the Police and Criminal Evidence Act, Section 24. And the courts have said that the need for bail conditions can be a reason. So I guess what you could do, I mean, the thing to do is to avoid voluntary attendance, because it's not appropriate. Plus, the perpetrator's got time in advance to kind of like plan what they're going to say. They can, they can delete evidence from their computers. They can get rid of phones and all sorts of things like that. So the police shouldn't be doing that. They should be arresting. But if they've already done that, one option you could say is, please go back, and now, even though you've interviewed him, arrest him anyway in order to use bail conditions. That would be quite a new thing to do, but it's something you could try.
Okay, but what if the perpetrator is getting advice and the person giving him advice says, quickly go to the police station so that you will not be given, the bail? So it depends on
if that's right. If perpetrators are told beforehand that the police want to interview them, then they will come along. And I know the police often find it more convenient. So, you do it in a custody suite, you can do it at a convenient time. You don't have to send officers out to arrest the person. So there's been a huge increase in the use of voluntary attendance since the changes to the law on bail in 2017. And, that has created a problem, because it's meant that bail is being used much less and there's less protections. Incidentally, the day before yesterday, the police inspectorate published a new report on bail and RUI, release under investigation. And one of the things that they've said, they've been investigating this for 18 months as well, alongside our super complaint. And they say that bail is not being used enough in domestic abuse cases. And one of their recommendations is that bail conditions should be used in all high-risk cases, such as domestic abuse and harassment and stalking cases. And we really, really welcome that, because although there was some new police guidance in last year, after we put the super complaint in, the guidance wasn't as strong as we would have liked. And that guidance said police should give serious consideration to using bail, whereas this report says all cases in domestic abuse and harassment and stalking should have bail conditions. And obviously these are cases where there's always repeat offending, obviously stalking by definition, but with domestic abuse, you very rarely get a one-off, So the fact that you've already had repeat victimization in one form or another shows that you need bail conditions. So that's a really great report, and I hope that people can use that to support their requests for for bail conditions.
Thank you. I'm sure there will be a lot of information we'll have to get from you after this.
You're very welcome to get in touch.
The next question is from Liliana. What are the numbers of the VRR successes in cases of domestic abuse?
That's a very good question, which I'm afraid I don't know the answer to. I mean, VRRs are done all over the country by different forces. If you're talking about police VRRs, and we don't have, I don't think the figures have been published anywhere. I mean, it may be that we can do some freedom of information requests to find out. I know that the only figures that I'm aware of VRR outcomes is CPS VRRs during the very early period. So CPS VRR was introduced in 2013, and then police VRR was introduced in 2015. And I think the first couple of years of the CPS scheme, there was the positive outcomes was 14%. So again, it's not, you know, it's not a very high number, but it is something. And I think the figures were higher for rape cases. From memory, I think the rape cases were about 18%. And there were cases where, in rape cases that we know of, where decisions were overturned and charges were brought and convictions were secured. I mean, obviously some of those may have been acquitted, but there were some cases where offenders were convicted. So those are, but I don't know any figures for domestic abuse cases, I'm afraid. Also, I don't know why this is, but what I have found from all of the training we've done around the country and all the inquiries that we get, we seem to have a lot more VRR requests in rape cases than we do in domestic abuse cases. I don't know why that is. We seem to have a lot of requests from ISVAs, you know, sexual violence advocates in rape crisis centres, a lot more than we get from IDVAs. I'm not sure if that's because of the support workers having a different approach, or because of their clients feeling differently about how far they want to push it, or but I'd be really like to know, those figures, and it'd be interesting to do some research at some point one day.
Thank you for that. The next question is from Heidi. Why don't the police arrest for breaching bail conditions that they put in place?
Yeah, that's another good question. So people often refer to pre-charge bail as the toothless tiger. And so there's two different types of police bail. There's pre-charge bail and there's post-charge bail. So for post-charge bail is a lot stronger, because if somebody breaches post-charge bail, they can be remanded in custody because they've been charged already. So I think there's better chance of the police arresting for those kind of breaches. With pre-charge bail, the problem is that it's not possible because the person hasn't been charged yet. They can't be remanded in custody, because you can't put somebody, in prison for something they haven't actually been charged with yet. So the only thing the police can do is they can arrest, take the person to the police station, look to see if they can charge. If they can't, they just have to release them again. So sometimes, if the perpetrator is like hammering on the door, then yes, the police should turn up and arrest them, at least to give a bit of protection. But if it's a breach like a text message or something like that, often the police think, well, what's the point in, turning up, arresting them, releasing them again? And one of the things that some forces do, I know I was speaking to North Yorkshire Police, an officer there who said that they do that in that force, is use domestic violence protection orders where there have been repeated breaches of police bail. So then if the DVPO, if there have been the really repeat breaches of pre-charge bail, if a DVPO is put on and that is breached, then they can take the perpetrator to court for contempt of court. So I know that's kind of a bit of something going on and on and on. And a lot of victims then end up feeling like, well, nothing's happening. What's the point in reporting these breaches? Nothing ever happens. And it just feels like it's a waste of time. And I really know that there's a massive problem around this. I would say that the domestic abuse bill is going to introduce these new orders, the DAPOs, domestic abuse protection orders. And one of the things we've been saying is that we've been involved with the Home Office looking at the new orders. And we've been saying that we think if there's a breach of pre-charge bail, that should automatically trigger a DAPO. And then if a DAPO is breached, that'll be a criminal offence. If you breach a DVPO at the moment, that's not a criminal offence. But if you breach a DAPO, it will be a criminal offence. And hopefully that'll be a stronger, a bit more teeth behind it. And hopefully the police will then take a bit more action because they'll have a bit more power. And, we need to push them to do that. Yeah.
Good. There is a very interesting question from John. Is there a stated case to retrospectively arresting after the interview purely to give bail conditions?
So no, there's no case that I'm currently aware of that has exactly that situation, that circumstance. So I think, I'm not aware of that actually happening, but we've certainly suggested that and people have gone away. I don't know if they followed it up, but I think there is a good legal argument if you look at the two cases that do say that the necessity, the test for necessity for arrest in section 24 of PACE is met, where there's a need to arrest for the purposes of bail conditions. So I've not known it to be used in this context that I've just suggested of arresting after interview, but I don't see why it couldn't be. So I think it's a case of have a go and see. And certainly that's something that we will be very interested in following up on if people have got that particular situation. Certainly something we've discussed with domestic abuse support workers in the past.
Okay, thank you, Nogah. And the next question is from Summer. Are there any more informal processes that could be considered when supporting a victim with challenging the police decision, such as not to charge for a breach of civil order, non-molestation prohibited steps?
Okay, so a breach of a non-mol is in itself a criminal offence. So the non-mol is civil, but the breach makes it a criminal offence. So if the police decide not to charge for that breach, it is actually exactly the same as any other decision not to charge. It's an NFA decision, and you can challenge it through victims' right to review. There are lots of situations where it is really worth pursuing things informally first. Like, I wouldn't jump to making a formal police complaint, for example, because you can have a chat with the officers in the case. You might want to have a chat with their senior. You might want to get somebody to contact, the SPOC, the single point of contact, who deals with harassment, stalking, or domestic abuse within the force. All sorts of ways to try to kind of resolve things in a positive and constructive way with the police. Because obviously you're all there, you're all trying to assist the victim. You're all on the same side trying to get the best outcome for victims. So I would advise, all those things before you go to a formal complaint. But when it comes to a decision not to charge, actually, there isn't really a halfway house. It's either a victim's right to review or nothing, I think. I mean, sometimes you could have a chat with the officers in the case and say, could you look at this again, and try to push them to arrest. But if they have investigated and they've looked at all the evidence and they've decided not to charge, then generally it is a victim's right to review. If they haven't arrested, sometimes with a breach of a non-mol, what happens is the police just don't bother to arrest and don't investigate. And in that situation, it's a matter of trying to push them to actually investigate and arrest in the first place. So then that would be informal, speaking to the officers in the case and saying, look, this is an offence she's reported, explain the impact on her, the long history, because often people, police might think, oh, it's only a few text messages or something small. You've got to look at the whole history. What is all of the abuse that actually led to the non-mol being granted in the first place? This is usually part of a long pattern, and police sometimes just look at incidents in isolation and don't really look at them in terms of the whole history of the abuse that's happened before. So, try to get them to understand that and to arrest. Yeah.
Yeah, thank you, Nogah. Right, we are just 2 minutes after 3 o'clock, and I'll just ask for your permission. Are you okay for us to continue for the next 10 to 15 minutes?
Yeah, sure, that's fine.
Yeah, because I've got some questions popping up for me. Right, the next question is from Rachel. Why is there such a difference in CPS charging standards and police charging standards? Often, police reports are shown as ABH or a higher charge, but CPS will authorize a charge only for a common assault and battery.
That's a very, very good question. There shouldn't be a difference. The charging standards, the guidance on the legal guidance for offences should be the same. But I think if you're seeing that, I think it probably reflects prosecutors being more cautious in those cases. So, I mean, sometimes it might be that the police officers think, oh, we've got all this great evidence, and the prosecutor is aware of why some of that evidence can't be used for whatever reason, it doesn't meet legal tests, or the prosecutor might be, might think actually we can't prove this in court, or we can't prove that in court. But I think a lot of the time it's also down to kind of like a culture of how cautious the decision makers are. And for example, on rape charging, you know, one of the issues that we've been dealing with the CPS is what we think is a culture of sort of being overcautious about rape charging in CPS cases by the CPS, for example. So it can also be that. You know, the report on harassment and stalking said that the CPS were routinely downgrading, you know, downgrading stalking to harassment and downgrading Section 4 offences, which are the more serious offences, down to Section 2 offences, which are the less serious offences. So it could be that as well. So I think it depends. It depends on the case and depends on the sort of culture of your local force and your local CPS office.
Okay, thank you. Wonderful. The next question is from John. Police are not completing interviews voluntarily for their convenience. This started when the legislators changed Code G of PACE to ensure the justification around arrest and release on bail was sound. This came after the high-profile cases involving Sir Richard, Cliff Richards, and the MP. What do you have to say to that?
So I think there are two different points there. I think in terms of the high profile cases, what you're probably referring to is the changes to the rules on bail, which were introduced in the 2017 Act, which introduced a presumption against bail unless bail is necessary and proportionate. And what we have said is that actually in domestic abuse cases, bail is necessary and proportionate, and that more cases should be dealt with bail. So I think that's something certainly, you know, looking at the report that was published a couple of days ago, and also the Home Office review on bail, I think there's a sort of a general view that the change in the law that followed the high profile cases was, you know, the pendulum swung too far that way. But just the other point I wanted to mention there about the legal test for arrest, which I think maybe is more specifically what you mentioned. It is true that the legal tests that whether it's necessary to arrest or whether you can carry out or whether you should carry out a voluntary interview will generally look at whether, firstly, whether the accused, whether their address is known and they're not a flight risk, and secondly, whether they are willing to come in for a voluntary interview. And there are a few cases that have gone to the courts where the courts have said that where the accused is known, they're not a flight risk, they're willing to come in, it wouldn't be lawful to arrest them. You need to interview them on a voluntary basis. But what we're saying is that in those cases, there wasn't any need for bail conditions to protect anybody, to protect any victim in those cases. So those cases were limited to those factors. But when you also have an additional factor, which is the need to protect a victim with bail conditions, then there are additional reasons why it is necessary to arrest under the codes of practice, which were not considered in those cases. And that's where you come on to the two cases that I mentioned, which I'm happy to send. John, I'm happy if you want to contact us, I'm happy to send you those cases, where the courts have confirmed that, you know, a need to have bail conditions can be an additional factor. So yes, in many cases, the police, you know, may feel that they've got no option. They have to do a voluntary attendance. But what we say is that that's not the case where there's a need for bail conditions. And that's where, you know, I think that's where there's a need for the law to be clarified, that voluntary attendance is not appropriate there.
Okay, thank you. I hope John will contact the organizers to get the answers and the document you said. Thank you. Right, the next question is from Melanie. Do you think there is a scope in the future for timescales to be extended? Always difficult when a victim reaches a place where they are ready to disclose abuse and want to report, and then prevent future victims, that then historic abuse cannot be investigated if not in timescales for offence.
So this is about offences that have the 6-month time limit, and that is only the offences that can only go to the magistrates' courts as what they call summary offences. So generally speaking, for domestic abuse, that will just be common assault and Section 2, stalking harassment. I don't think that that 6-month time limit is going to be changed, because it doesn't just apply to domestic abuse. It applies to all summary offences, and I can't see that changing. But one thing I would say, and we've sort of had this be used in lots of cases, is that if you look on the CPS website under offences against the person, there's a section there about whether an offence should be charged as common assault or ABH. And there are lots of cases actually which can be charged as ABH. And if they're charged as ABH, there wouldn't be any 6-month deadline or any kind of deadline at all. And that includes, for example, cases where there have been multiple repeat assaults on the same victim. Even if each separate individual assault may normally be a common assault because there's no like serious injuries, if you look at them cumulatively, and obviously in domestic abuse you often have a pattern, it's not a one-off incident. If you look at them as a pattern, then they could be charged as ABH. The other classic example is strangulation, and the guidance does say that where you've got strangulation or, for example, dunking in the bath, especially if somebody has lost consciousness, that the degree of violence involved there means it could be charged as ABH and not common assault. Another one is where a weapon's been used or there's been kicks or punches, kicks or headbutts. So there may be some cases that you think are have got a 6-month deadline, but actually they might come under ABH and then there's no deadline. So that is worth looking at in the CPS guidance. Yeah.
Thank you. I'm going to take just 2 questions and then we will have to end up for today. Right. The next question is from Jacqueline. If police are called to a domestic incident and an allegation is made, but the alleged perpetrator is prepared to leave the home, do they still have to make an arrest, or is there any discretion in this?
So there's always a discretion. It's a decision for the officers, but on the whole, the police service in the UK, and this will also be down to each local force, will have its own policies on domestic abuse. But generally speaking, since 2008, the police service adopted a positive action approach to domestic abuse. So that generally means that if the evidence is there to make an arrest, that officers, if they have the legal basis to arrest, that they should arrest. So that's where, if you adopt a positive action approach, that's where domestic abuse is a bit different to other kinds of offences, like, no shoplifting or some other kind of offence. So you may want to look at the local force policy and see if they've adopted a positive action approach. But most forces do, and I think that is a kind of national guidance since 2008 in terms of domestic abuse. So yes, if there are reasonable grounds for suspicion, which is the legal power, and it's necessary to arrest for one of the grounds of necessity, which can be to investigate the crime, to interview the suspect, to have bail conditions, and so on, then positive action normally would require arrest or other kinds of protection, like a DVPO, for example.
Thank you. And my very last question for today from Angela. Do you think we will one day have an actual offence of domestic violence and abuse rather than using assault?
I don't think domestic abuse or domestic violence does come in many shapes and forms. So I don't think we will, because I'm not sure that we need it. I think what we have is quite a broad range of offences. We've got, for example, coercive controlling behaviour, which is probably could be used a lot more than it is. We've got all sorts of offences like revenge porn, harassment and stalking that could be used a lot more. So there's lots of domestic abuse offences which don't require physical violence. And I think there's more and more awareness of that and more use of those offences. So I'm not sure it would make sense to have just a single offence of domestic abuse or domestic violence. But I think what we should be doing is using all those other offences. And I think sometimes police officers still think in terms of the old-fashioned idea of domestic abuse is all about violence and it's all about injuries and, cuts and bruises and so on. And what we need is a better appreciation of what coercive controlling behaviour means, what stalking means, and how tied up all those things are with abuse, so that we're using the full range of offences that we have available.
Thank you so much, Nogah. Is there any other thing you want to leave with us today before we call it a day? Any other thing you would like to leave for us?
Well, no, I mean, I think I'm sorry I've tried to squeeze in a lot in a short space of time, but I'm really, I'm really pleased that you've invited me, and I really hope that this has sort of sparked further conversations, maybe amongst the participants and amongst your audience, because I'm sure some of you, obviously some of you work within the police force, some of you work with the police, and I think what we all want to do is think about how we can all improve what we do for victims. At the end of the day, all of us are trying to get better outcomes for victims, and it's a matter of working together constructively to try to use the law as best we can.
That's right. That's right. Thank you so much. Well, thank you so much, Nogah Ofer. That was absolutely fantastic. And I'm sure something we will all be going away thinking about. Thanks to everyone who asked a question that really added to the conversation. A recording of this webinar will be made available to you shortly. If you enjoyed this event, please do note that there is still time to register for the upcoming webinars. And tomorrow is the very last day, so we're still taking registration 2 hours before the event starts. So if you've enjoyed it, you go to www.daeverybodiesbusiness.org to register. We can also keep the conversation going with the hashtag #DAEverybodiesBusiness and hashtag #NoCSpeakOut. So let's keep doing this and making domestic abuse everybody's business. If the talk today has raised anything with you personally, and you would like to find out more about the services available, please visit domesticabuseservices.org.uk, and you can also visit, that's a link that is just right in front of your screen, when you can find out more about how to refer anyone into your local services. So from me to you today, I would like to say thank you so much for attending this webinar, and if you have any question, send email to the organizers. And have a wonderful afternoon, everyone. And thank you, Nogah, for today.